Hello there, this is Clifford from Clifford Odhiambo and Company Advocates. We are located at Jumia Place along Lenana Road in Hurlingham. Today we look at the recent decision of the High Court in the case of EKTM versus ECC, which was delivered by the Honorable Mchelule. This case may be also cited as Nairobi's Civil Appeal number 62 of 2022 EKLR. The case answers the question, under what circumstances can a step-parent be ordered to take up parental responsibility of a minor? This was a civil appeal from the decision of the magistrate court, in which case the trial court had ordered the appellant to take up parental responsibility of all the children born by the respondent. The appellant, while before the magistrate court, had disputed parental responsibility of the 2 out of the 3 children born by the respondent. However, all these children were born while the appellant was married to the respondent. Dissatisfied with the decision of the magistrate court, the appellant appealed to the High Court. And this is where we pick up this case from. From the facts of this case, we learn that the respondent had given birth to 3 children. Out of these 3 children, it was not in dispute that the appellant was the biological father to only 1 out of the 3 children. It was, however, the respondent's argument in court that at the time she was consummating her marriage with the appellant, she was 5 months pregnant. This was an issue which the appellant knew of, and not only did he know about this issue, but he also gave the minor his name at the time she was born, which name currently appears in a birth certificate. It was also admitted by the respondent in the case that at the time she was in a relationship with the appellant, she had an affair with another man, and out of this affair, she gave birth to another child. The paternity of these 2 last children is one of the issues why the parties are at loggerheads in an ongoing divorce case. The appellant, on the other hand, argued that he provided for the food, shelter, clothing, and all the other expenses for the 3 children because he believed he was their biological father. The magistrate court had ordered the appellant to cater for the educational, medical expenses of the children. On top of this, the magistrate court had ordered the appellant to pay 30,000 monthly towards the upkeep of the children. In the end, the Honorable Justice Mchelule upheld the appeal only to the extent that the appellant was required to pay 30,000 towards the upkeep of all the children, including those 2 children that were not his biological children. The respondent, on the other hand, was ordered by the court to cater for the food, shelter, clothing, house help, and other needs for the children. The High Court, just like the Magistrate Court, based its decision on Section 94(1) of the Children's Act. This particular provision is meant to guide courts in ascertaining how much parental responsibility a step-parent ought to assume. Additionally, this particular provision of the law is meant to guide the court in ascertaining the specific needs of the child, while at the same time looking at the financial and other capabilities of a step-parent in determining what responsibility is to be assumed by either parent. In any event, the needs of the child should not be such that at the end of the day, the parents are left in a financial distress. The second reason taken into consideration by Honorable Mchelule is that the appellant had continuously provided for the children and brought them up. The court also took into consideration the number of years that the appellant had related with the children. This, the court assumed that the appellant had taken up parental responsibility just like any other father would have. It is important to point out that the Magistrate Court delivered its decision on 2nd December 2020, while the High Court in the present appeal delivered its judgment on 25th April 2022. In our observation, both courts placed reliance on Section 94(1) in apportioning parental responsibility upon the appellant as the stepfather to the 2 children. Now, this is long after Honorable Njagi had declared the said provision of the law as unconstitutional in a judgment that he delivered on 17th February 2019. Despite these misgivings, this still remains the law. unless the decision is set aside by a superior court. This case also highlights another issue, which is the legal minefield left behind by courts long after they have declared certain provisions of the law unconstitutional. Unless these provisions are redacted from the actual provisions of the law, both courts and the members of the public will continue to fall prey by relying on provisions of the law that have been declared as unconstitutional. Well, that's it for now. Hope to see you next time.